In Charleston in November 1718, Stede Bonnet did not try to prove piracy had never happened. The ships were real. The cargo was real. The witnesses were in the room. His defense came down to one word: orders. The prosecution said Bonnet commanded the Royal James when the sloops Francis and Fortune were seized. Bonnet said the crew acted without him. He said Blackbeard had ruined him first. He said he had no real power. The transcript does not read like a legend. It reads like a machine built to test that claim, name by name, prize by prize, witness by witness. The question is not whether Stede Bonnet was unusual. The question is narrower and harder. What did the Charleston trial actually prove about command, responsibility, and the alias that carried him to the mouth of the Cape Fear River? The answer begins before the courtroom, but not with childhood. It begins with a coast that had learned to read sail plans as threats. Put Charlestown on a harbor map in 1718, and the problem is plain. The town lived by water. Vessels moved in and out carrying sugar, rum, rice, indigo, provisions, people, and news. A pirate sloop near the bar was not color. It was a commercial emergency. The printed trial record says the province had suffered repeated insults from pirates over the previous 3 years. It named Stede Bonnet as one of the men who had struck the Carolina coast before. In August 1717, Bonnet had appeared off the South Carolina bar and taken 2 vessels. One was a sloop from Barbados carrying enslaved people, rum and sugar. Another was a New England brigantine. The brigantine was stripped and released. The sloop was taken away, used, and burned. That is the first screen of evidence: ship, cargo, master, place, loss. Then came Blackbeard. In June 1718, Blackbeard's force appeared off Charlestown with a ship called Queen Anne's Revenge, Bonnet's former sloop, and other tenders. Bonnet was present, but the Charleston account says he was not in command. The pirates took prizes, held prisoners, and demanded a chest of medicines from the government. That moment matters because Bonnet later tried to use Blackbeard as an explanation. Blackbeard had taken power over him. Blackbeard had stripped him. Blackbeard had left him exposed. Some of that story has record support. Some of it belongs to Johnson's 1724 version. The careful line is this: contemporary trial material in the printed Charleston account put Bonnet with Blackbeard and then show Bonnet resuming command afterward. Johnson's later history adds Bonnet's humiliation, shame, melancholy, and private regret. The trial does not prove that inner life. It proves what happened after it. After Blackbeard wrecked Queen Anne's Revenge near Topsail Inlet, Bonnet recovered his own sloop. He had received the king's pardon in North Carolina. He also had a path back into legality, at least in theory. The new war with Spain made privateering possible again. A lawful commission against Spanish shipping could have turned a damaged reputation into a defensible voyage. But the voyage that followed did not stay inside that line. Now the evidence chain begins. Bonnet used aliases. The trial title called him Stede Bonnet, alias Edwards, alias Thomas. His sloop, formerly Revenge, was now Royal James. On screen, those names should sit beside the 2 ships that would later hang the case on him, Francis and Fortune. The Royal James moved north and took vessels near Virginia and Delaware Bay. Some prizes were stripped for provisions. Some were kept. By late July, 2 captures became central to the Charleston indictment. The first was the Francis, commanded by Peterman Waring. The second was the Fortune, commanded by Thomas Reed. The prosecution could have tried to prove more. Judge Nicholas Trott later told Bonnet that the evidence at trial reached no fewer than 13 vessels since North Carolina. But the court chose 2 indictments. That choice gave the case its shape: 2 ships, 2 named commanders, 2 acts that a jury could understand. The Royal James then went south to Cape Fear. Cape Fear was not a scenic hideout. It was an inlet, a river mouth, sandbars, shoal water, timber, and space to careen a leaking sloop. On a map, it looks less like shelter than a trap waiting for the wrong tide. That geography made the capture possible. Word reached South Carolina that a pirate sloop of 10 guns and about 60 men was in the Cape Fear River with 2 prizes, careening and refitting. Governor Robert Johnson accepted an offer from Colonel William Rhett to go after it. Rhett took 2 armed sloops, the Henry, with 8 guns and about 70 men under Captain John Masters, and the Sea Nymph, also with 8 guns and about 60 men under Captain Farrer Hall. On September 26, 1718, Rhett entered the mouth of the Cape Fear River. The first thing the river did was stop him. The pilots ran the South Carolina sloops aground. Darkness came before they were fully free. Upstream, Bonnet's men saw the vessels but did not know who they were. They sent 3 canoes to inspect them. The canoes returned with the answer. These were not easy prizes, they were armed vessels. That night, the pirates prepared to fight. The next morning, Saturday, September 27th, Bonnet's sloop came down the river. The printed account says his plan was a running fight, a move toward open water. Rhett tried to put his sloops on either quarter and board. Bonnet edged toward shore. In the shoal water, the Royal James grounded. Rhett's vessels grounded too. For hours, the battle became a strange, fixed fight between vessels stuck in mud and sand. The trial account gives the geometry. Rhett's Henry grounded within pistol shot of the pirate sloop and on her bow. The other sloop grounded ahead and almost out of gunshot, which made her less useful while they lay stuck. The Royal James listed away from Rhett's vessel, covering many of Bonnet's men. The Henry listed the same way, exposing Rhett's. The accounts put the firing at roughly 5 to 6 hours while the sloops were aground. The casualties were heavy for a colonial action of this scale. On the Henry, 10 men were killed and 14 wounded. On the Sea Nymph, 2 were killed and 4 wounded. Among Bonnet's crew, 7 were killed and 5 wounded. 2 of the wounded died soon after. The numbers matter because Trott later made them part of the moral and legal argument. In his sentence speech, he treated the deaths on Rhett's side not as battlefield fortune, but as murder by men who had no lawful authority to fight. Once Rhett's sloop floated free, the advantage changed. He moved to finish the action. Bonnet sent a flag of truce. The Royal James surrendered. The South Carolinians discovered that Captain Thomas was Stede Bonnet. That recognition is the first courtroom beat before the courtroom exists. A man with a pardon under one name, a sloop under another name, and a recent chain of prizes had been caught with the 2 vessels that would become the legal spine of the case. Rhett left Cape Fear on September 30th and arrived at Charlestown on October 3rd. 2 days later, the prisoners were put ashore. Charleston had no permanent prison fit for this group. Most of the crew went to the watch house under militia guard. Bonnet, because of rank and social standing, was placed under the marshal's custody at the marshal's house. That distinction almost changed the case. David Harriet, the sailing master, and Ignatius Pell, the boatswain, were removed from the rest of the crew and held with Bonnet because they were expected to give evidence. On October 24th, Bonnet and Harriet escaped. Pell did not go. The escape made the trial stranger. On October 28th, the Court of Vice Admiralty opened in Charlestown, but the man whose name stood at the head of the case was missing. The court began anyway. This is where the common picture of one dramatic pirate trial breaks down. The Charleston proceedings were a series of trials. The defendants were divided into groups. The indictments were found by a grand jury. Petit jury heard the cases. Most pleaded not guilty. A few pleaded guilty. 4 were acquitted. Thomas Nichols, Roland Sharp, Jonathan Clark, and Thomas Girard. 29 were condemned. The court did not need a single theatrical day. It needed repetition, indictment, arraignment, witness, verdict, sentence. The crew's trial built the legal ground Bonnet would later stand on. The court had already accepted that the Francis and Fortune were taken by piracy. The remaining question for Bonnet was whether he could detach himself from the command structure that took them. While the court moved through the crew, the search for Bonnet continued. Governor Johnson issued a reward of £700 for his capture. Rhett was sent again. Bonnet and Harriet were found on Sullivan's Island. Harriet was killed in the encounter. 2 others with Bonnet, identified in the record as a black man and an indigenous man, were wounded. The record does not give them full names or interior lives. It records them as people caught inside the machinery of the case, then moves on. Bonnet surrendered. On November 6th, he was brought back to Charlestown and placed in safer custody. 4 days later, his trial began. Now the contradiction sharpened. The prosecution's case was simple enough to fit on a courtroom table. Royal James, Francis, Fortune, Bonnet, Pell, Manwaring, Reed. The sloop had taken the prizes. The goods had been removed. Witnesses could identify him. The earlier trials had already sorted much of the crew's participation. Bonnet's defense tried to pull that chain apart. He pleaded not guilty to the first indictment. He said he had been forced. He said his men had carried out robberies against his will. He said he had often asked them to stop and put him ashore. He blamed Blackbeard for stripping him of resources and leaving him in a situation where his men would not obey. For the Francis, he claimed he was asleep when the vessel was taken. It was a defense built on distance. Distance from command, distance from intent, distance from the men who acted around him. The prosecution answered with presence. Ignatius Pell placed Bonnet inside the command structure. The prize captains placed him at the captures. Then came the exchange the whole case had been moving toward. Captain Peter Manwaring of the Francis testified about the taking of his sloop and goods. Bonnet cross-examined him and pressed the narrow point. Had Manwaring heard Bonnet order the goods removed? No. That answer gave Bonnet the gap he needed. No heard order, no direct command, no sentence that could be repeated as proof. But Manwaring still treated Bonnet as responsible for the loss. That exchange is one of the most revealing moments in the case. Bonnet understood where the crack had to be. If no one heard an order, perhaps command could be made invisible. The prosecution answered with the shape of the voyage, the renamed sloop, the aliases, the captured prizes, the witness chain, and Bonnet's place at the center of it. Other witnesses pushed further. Some testimony connected Bonnet to orders and threats. The trial material preserved a claim that Bonnet declared he would shoot any man who refused to fight. The exact force of that line is lost to the courtroom format. Its legal function is clear. It made Bonnet not a passenger, not a victim of his own crew, but a man enforcing resistance. That is the midpoint of the case. The trial was not trying to solve why Stede Bonnet left Barbados. It was testing whether a man could carry command when command became useful, then deny it when command became capital evidence. After the first conviction, Bonnet changed his plea on the second indictment. He pleaded guilty to the fortune charge. On November 12th, Trott sentenced him to death. The sentence speech is long, moral, legal, and severe. It is also one of the reasons Bonnet's case is so valuable. Trott did not simply say the law required hanging. He explained how the court wanted the case read. Bonnet had education. Bonnet had rank. Bonnet had already received mercy through the pardon. Bonnet had returned to the sea under aliases. Bonnet's post-pardon acts were worse in Trott's eyes because they came after a lawful escape route had been offered. Trott also widened the indictment without formally widening the conviction. Bonnet had been convicted on 2 charges, but Trott said the trial had proved many more captures since North Carolina. The court had prosecuted 2. The speech made 13 visible. That is why this transcript matters beyond Bonnet. It shows the state's method: reduce the indictment to 2 solid prizes, then use the sentencing speech to place those 2 inside a larger pattern of piracy. Now the source layer changes. Johnson's 1724 general history took Bonnet and made him memorable as an anomaly. Educated, wealthy, unsuited to the sea, possibly driven by mental disorder or by trouble in marriage. That version is old, influential, and not useless. Johnson also copied heavily from material close to the trial record, and much of his account of the Cape Fear fight follows the printed Charleston narrative. But Johnson is not the trial. The trial papers say Bonnet was tried for the Francis in Fortune, convicted on 1 indictment by a jury and guilty by plea on the second. They say he used aliases, commanded the Royal James, escaped custody, was recaptured, and was sentenced on November 12th. Johnson's 1724 history adds the inward explanation: a disturbed mind, domestic discomfort, shame, melancholy, and regret. No trial transcript, court minute, or contemporary newspaper can prove that inner motive. So the honest version is narrower. We do not know why Bonnet first chose piracy. We know what the court proved after he chose to return to it. That distinction changes the case. If the story is about an eccentric man who failed at piracy, the trial becomes the last scene in a character sketch. If the story is about the transcript, the trial becomes the main event. Ships, commanders, jurors, condemned men, acquitted men, pleas, witness pressure, and the precise defense Bonnet tried to make. It also shows what the surviving paper does not preserve: It does not give us a clean motive. It does not give the unnamed wounded men equal attention. It does not preserve the full experience of the captured crews. It does not turn Bonnet into a comic failure. On November 8th, before Bonnet's own sentence, most of the condemned crew were hanged at White Point near Charlestown. The Charleston County Public Library's analysis of local records notes that Bonnet's crew, and later Richard Worley's crew, were part of a broader series of piracy trials and executions in late 1718. The court minutes and local trial record do not preserve every practical detail of those hangings. They preserve enough to show a colony using public execution as a maritime warning. White Point was the edge of town, a visible place near the harbor. Ships entering or leaving could see it. The legal sentence moved bodies from courtroom to watch house to the place of execution. The geography made the punishment visible to the water. Bonnet waited longer than his crew. The printed trial transcript records that on Wednesday, December 10, 1718, he was executed at White Point near Charlestown, according to the sentence. The National Archives page for the Vice Admiralty Court minutes identifies November 12th as the sentencing minute for Bonnet's conviction on the Francis and Fortune charges. The archive's survival matters because it gives the printed transcript a second official anchor. The larger South Carolina paper trail is damaged. Legislative journals and accounts from 1718 and 1719 are lost. That loss keeps parts of the case closed. The full politics of the trial, the details of local custody, the precise handling of bodies, and the missing administrative conversations around Bonnet's escape. But the core survives. That survival is why Bonnet's case is stronger than the legend around him. The legend asks why a wealthy man went to sea. The surviving record asks how a man who had received mercy created the evidence that made mercy politically impossible the second time. Look at the chain: a pardon in North Carolina, an alias at sea, a renamed sloop, 2 captured vessels with named masters, a leaking refuge at Cape Fear, a battle in shoal water, an escape from custody, a recapture on Sullivan's Island, a trial where Bonnet denied command, a sentencing speech that made command the center of guilt. That chain is more specific than the famous nickname. It is stranger too, because it does not need Bonnet to be foolish. He knew enough to use aliases. He knew enough to seek legal cover. He knew enough to challenge whether a witness had heard him give orders. He knew the line he needed to blur. The jury's answer was that the line had already been crossed. This is what the transcript proves. Bonnet's downfall was not that he failed to match the romance of piracy. It was that, after pardon and alias and escape, the trial could still attach him to command. The wealthy Barbados planter sailed and never came home because the record did not have to solve his private reasons. It only had to follow his orders.